the most outrageous of the surreptitious acts. So for you, what are the 2 or 3 most important or significant things the DNC did to sabotage the Sanders campaign?
Yes, the lawsuit was filed summer of last year, and since then we've had 2 motions to dismiss, multiple hearings, and the last court hearing was in April. It was a 3.5-hour hearing on defendant's motion to dismiss. And it was a very interesting hearing, Paul, because the transcript, which is publicly available, I've made it available, the court was deeply concerned about the allegations in the complaint, the allegations of collusion, election rigging, and fraud, essentially. Nonetheless, last week, the court dismissed the complaint without prejudice. And in the past year or so, while this lawsuit was pending, there has been a lot of, I would say, very disturbing and odd activity outside of the courtroom, one of which is our process server, Mr. Sean Lucas, before he was to testify in court, offer his evidence in court, to rebut the defendant's first motion to dismiss for improper service, suddenly passed away. A young man, healthy, in his 30s, was found dead on the floor of his bathroom. Subsequent to that, Mr. Seth Rich, I understand Mr. Seth Rich was involved he was an employee of the DNC in, I believe, in some technological capacity. He was gunned down in cold blood on the streets of Washington, D.C. There have been numerous news reports on his death, and as yet it is still unsolved. Those are 2 major events that stick to my mind. There are other events, such as the ongoing harassment of my legal team, our employees, and the plaintiffs, which we have notified the court through court filings. One of the most odd occurrences involved a phone call my law firm received. The caller used a voice-changing technology to modify his or her voice to such an extent that we could not even recognize if it was a man or a woman calling. This anonymous caller asked a lot of questions about the lawsuit, but the odd thing is there was a number that popped up on the caller ID. And when we looked that number up, that number is the number to Congresswoman Debbie Wasserman Schultz's local South Florida office. Now, Congresswoman Debbie Wasserman Schultz is the former chair of the DNC, and she is a co-defendant in this lawsuit along with the DNC.
Okay, let's work our way through all of this, because you just kind of unloaded several bombs here. Let me quickly say what we know about the case, and then we'll deal with some of the points you just raised, and then we'll kind of come back to the case again. My understanding is the judge dismissed the case because he found that even though, as I read in the introduction, the DNC did come out and favor Clinton over Sanders, even though they maintained a public position and, according to the internal rules of the Democratic Party, are supposed to be neutral in the primaries, they clearly were not neutral, used resources and surreptitious methods to support Clinton over Sanders. And in a few seconds, we'll remind everybody of some examples of that. But let me just give me a quick yes or no. Did I get that part right?
You got it absolutely correct. I would just like to add to what you said that under the standard imposed on the court in considering a motion to dismiss, the court is obligated to take all those allegations as true. I would point out that the court is not saying that these are true, but for the purposes of considering a motion to dismiss, the court is obligated to take all the allegations as stated in the complaint as true and go from there.
Now, in their defense, did the DNC argue that these things were not true?
The DNC put forth a number of defenses in their motion to dismiss. One is that they had a First Amendment right to say whatever they want, to solicit donations from the voting base. A second issue they raised is that the allegations in the complaint are more of a political promise rather than fraudulent omissions and misrepresentations. And there were a number of other defenses. Now, when I read the court's order, what I saw is there is a fundamental issue here, an issue which may not be so much factual as legal. And that is, if you donate money to a political party, does that, as an initial matter, provide standing so that you may pursue your claims in court? I would say that whether or not that's a yes or a no is a preliminary, out-of-the-box question that needs to be answered before this lawsuit can get off the ground. So I think the court distilled the heart of the case here that we need to overcome in order to open up what can be a very, very long and complicated legal action.
So this is not over, this legal action?
First of all, I would never say it's not over till the fat lady sings, and I don't hear anybody singing. But I will say that it's definitely not over for more than one reason. One is that this action can be filed in any jurisdiction by any lawyer and any aggrieved party. Now, so far, this is the only action arising from these allegations that I am aware of. But there's nothing stopping anybody else from filing similar suits in their home state or home county.
Now, the judge did not find that the case could not be brought forward by the plaintiffs who were donors to the Sanders campaign. If I understand that correctly, and some people writing about the case are characterizing it this way, is that, yeah, they rigged it, but they can rig it. They're allowed. It's not illegal to have rigged it because it's only an internal DNC rule, and it's not a legal obligation, or nor is there a legal contract to make them be impartial the way the rule says that they should be. Is that correct?
That's an interesting point you bring up, because I think people get a little confused. The question is not whether the DNC, as they said at a hearing, we can pick our candidates in smoke-filled back rooms. That's not the question. The question is, if you're going to do that, but you state otherwise, does that give donors a cause of action in court? You can sell whatever you want. You can sell base metal, gold, silver. You can sell whatever you want. But if you're going to sell base metal as gold, now that's a different issue than selling base metal at an inflated price.
Because the DNC raised millions and millions of dollars, and part of the messaging of the DNC is we are impartial, and that turned out not to be true. That's more or less what your case is about.
That is true. Not only did they say it, not only did former chair Congresswoman Debbie Wasserman Schultz say it on national TV, but it's written in their charter in black and white.
Okay, let's remind people of 2 or 3 of the what you think are the most outrageous examples of how DNC favored Clinton over Sanders.
I think the documents that Guccifer 2.0 released showed that even before the Democratic primary has really gotten off the ground, they had already made the determination that Secretary Clinton would be the eventual nominee. Subsequent to the Guccifer 2.0 leaks, WikiLeaks released documents showing that the DNC and Secretary Clinton's campaign were so intertwined, it's sometimes difficult to see where one begins and one ends.
I mean, one of the examples was the debate schedule and such they thought favored Clinton. Donna Brazile apparently was handed questions to Clinton that to be expected in one of the debates. Is that correct? Are there any other examples like that you would point to?
There are examples like that. There are emails showing that they were exchanging information and data. And there's a treasure trove in WikiLeaks, and we've actually filed it. Some of the examples were filed in court. I invite the public to actually, instead of asking me about it, to go to the source documents, the court documents. They are publicly available, free of charge. And the website is www.jampack.us. That's J as in Jerry, A, M as in Michael, P as in Paul, A as in Apple, C as in Charlie.us. DNC lawsuit. If you go there, all of the court documents are available, including the amended complaint.
Now, Donna Brazil later, although she kind of evaded it in the beginning, she later acknowledged and sort of confessed that she had, in fact, passed these questions on. Wasserman Schultz had to resign. So there's not a lot of dispute about what's in those emails. Is that correct?
To my knowledge, nobody within the DNC has ever disputed the authenticity of those emails.
Okay. All right. So the case has been decided more on, you could say, not quite technicalities, but essentially the judge is saying the promise of impartiality is not enforceable in a court. That's the essence of his ruling?
I would say the essence of his ruling is whether or not donations to a political party give rise to a concept called standing, which is a recognizable injury that the courts can provide redress for, and that there is no case that has answered this question, yes or no.
Okay, and in terms of going forward, appealing and such, the legal team, clients are still discussing what to do next.
Appealing is definitely an option. I would have to go back and confer with my legal team to discuss what our next steps are, but rest assured we will certainly try to come to an answer as soon as possible and make it publicly available.
Okay, now let's go back to what you said initially. The young man, Seth Richards is his name?
Seth Rich?
Seth Rich. There's been enormous debate about whether or not he had anything to do with delivering the emails to WikiLeaks. If I understand it correctly, his family has said he did not. They don't believe his death has anything to do with this whole issue. It's still, of course, lots of people speculating. Now, you mentioned his name up front. Do you have some evidence that he was, in fact, connected to this?
Other than the fact that he potentially would have been a witness in our case, no.
Yeah, had it been so, was that an issue that the DNC and their legal team would have been aware of?
That he would have been, I would assume that anybody within the DNC that had any relevant information as to the allegations in the complaint of collusion and so forth would be material witnesses. I do understand that there has been a hefty reward offered for information leading to solving his death, and nobody has come forward to claim this prize. Now, your courier, not your courier, the person who served... Process server, yes. Process server was also killed. Do you have any evidence that that was something other than, I don't know... That was not murder. He was found dead on the floor of his bathroom by his girlfriend. Based on the information that I received from Capitol Police after months of harassment by me. They have provided some information to me directly. He was found dead on the floor of his bathroom. And then through other channels, I found out that he had a cocktail of drugs in his system, a muscle relaxant, kratom, and I believe the third one was fentanyl or fentanyl. And any reason to think there's some foul play involved in this? Is there any evidence of that so far? I don't know what evidence of foul play is. There's no suicide note. He was the autopsy has not been released. I don't know why a routine examination of him would they would do a test for kratom. Kratom is somewhat of an unusual substance, I'm told. But they tested for it, so I don't know. I don't work in a coroner's office. I don't know what their standard operating procedures are. I don't know if it's standard to test for kratom. And the significance, of course, of the Seth Rich story is that whether in fact Russia had anything to do with these emails making their way to WikiLeaks or not, the alternative theory is that they were downloaded on some kind of a hard drive and then delivered to WikiLeaks. Do you have an opinion either way on who actually was responsible for releasing these emails? I don't have any direct knowledge. I do know that WikiLeaks has a policy of not outing their leakers. But as to the Russia story, I have spoken with many people, and I think calling that it's unsubstantiated is my understanding. The Russia narrative is unsubstantiated.
And in terms of this phone call that was received that you tracked back to Wasserman Schultz's number, explain again what that call was trying to do.
The caller asked if Beck and Lee was one of the law firms involved in the DNC fraud.
Have standing. Does anyone have standing to make the DNC actually adhere to the rules that they are supposed to be following?
As a general legal matter, nothing provides more standing in a court of law than the loss of money. So it is our position that the classes do have standing, even if the loss of money, in this case, is money that they paid to a political candidate. But that is, under those facts, it's a case of, I believe, first impression for a court.
Well, what about the question of do you think Bernie Sanders would have standing or more standing, and has he said anything about this case?
Bernie who?
Bernie Sanders.
Oh, him. Right. You know, I really don't think about him very much now.
Because
he's not running for anything.
Well,
Why do I?
He's certainly out there campaigning. He's certainly campaigning, whether he's campaigning for an office or not.
I'm not his constituent. I believe he's a senator from Vermont. I'm not his constituent. He's not running for anything. So I'm not his lawyer. I've never represented him. So I really don't think about him very much.
But has he commented on the case, to your knowledge?
To my knowledge, no.
Because you think he also suffered, in some ways, suffered more directly or more than donors did. But
I don't know if he suffered. I don't know what he suffered. I don't know what he suffered. I doubt that. I really doubt that he suffered more than his donors, many of whom went into their gas and grocery money to donate to his campaign.
Okay. We have a question from Nancy on Facebook. Should the ruling be used to argue a case against the 15% hurdle for other political parties? Although I'm not sure I understand how that relates to this. Does that?
I'm sorry, I don't think I quite understand.
I don't think it connects to this. This idea that the judge essentially is saying, if I understand it correctly, yes, the issue of standing of donors, but is he also saying, in terms of their free speech argument or in terms of the enforcement of these rules, that the rules simply are not enforceable? It's an internal guideline they can follow or not follow. Is the judge saying that?
That is one of the arguments put forth by the DNC. We strenuously disagree with that. Internal processes are separate from fraud claims. When you make a representation or omit to make a material representation that is different from your internal policies, then those internal policies do become an issue that can be redressed in court. But I think the issue here is there's also a legal doctrine that says that gifts are not damages. So if you give $100 as a birthday present to someone and you don't expect anything, now you may have an expectation that the person who received your funds as a present probably not use it for illegal means. But once you give that money, it's a gift. It's a gift. You don't have any legal claim to that money anymore. So there's a doctrine of gifting. On the other hand, there is I would say a more generalized legal concept that when someone defrauds you of your funds, that is a common law recognizable injury in court. It goes back hundreds of years. So the question here is when you have written in the charter that a political party will run a primary race in a fair and even-handed manner. Its chair, which is equivalent, I would say, to being a CEO, comes out on national TV and says, we run these races in a fair and impartial manner. And people cut checks and send money to the candidates based on those representations. Is that more like giving your nephew $50 for his birthday? Or is it more like making bets at the Kentucky Derby? I can tell you that if the Kentucky Derby, from the get-go, rigged it so that one of their favorite horses would win, there would be an uproar. So that is the question that is before us.
Right. Okay, we have a question. I think this is probably coming, maybe the last question. Richard from Facebook, can you describe any pressure, if there was any, from the DNC to back away from this case?
That's a good question. I think plaintiffs' cases tend to be difficult from the get-go, but in this particular case, we've had so many events. I don't even know where to begin. We've had I've never been involved in a case where so many people seem to pass away suddenly. It's just a very strange case.
All right, thanks very much for joining us, Elizabeth.
Thank you.
And thank you for joining us on the Real News Network.